5 seconds to go. Start. The facts as they stand in the present case are clearly in contrast to those contained in Shivanandan C.T. Supra, as opposed to the rules having made a specific provision. The rules were clearly silent in the present case. It is in this backdrop, in the face of the silence of the statutory rules, that the High Court had, in its initial full court resolution dated 29th January 2013, prescribed an overall cutoff of 50% of combined marks in the written test and in the viva voce. The High Court, while amending the text of its full court resolution of 29th January 2013, had done so in the exercise of the same administrative capacity which it had wielded while formulating the original resolution. Hence, the resolution of the High Court dated 30th November 2021 cannot be faulted in that regard. The unsuccessful candidates in the present case have further relied on Shivanandan C.T. Supra to contend that the absence of notice to the candidates about the imposition of the minimum cutoff marks for the viva voce contravenes their legitimate expectation. In Shivanandan C.T. Supra, this court held that an individual who claims a benefit or entitlement based on the doctrine of legitimate expectation has to establish the legitimacy of the expectation and that the denial of the legitimate expectation led to a violation of Article 14. In Shivanandan C.T. Supra, the statutory rules coupled with the scheme of the High Court generated a legitimate expectation that the merit list would be drawn based on the aggregate of the total marks received in the written examination and viva voce, and there would be no minimum cutoff marks for the viva voce. However, in the present case, neither the statutory rules nor the High Court committed that there would be no cutoff marks for the viva voce so as to give rise to such a legitimate expectation on behalf of the petitioners. Furthermore, the decision of the High Court to apply the minimum cutoff marks for the viva voce is grounded in legality and therefore cannot be faulted for contravening the established practice. Articles 233, 234 and 235 of the Constitution of India. That leads us to the analysis of the provisions of Articles 233, 234 and 235 of the Constitution. Clause 1 of Article 233 stipulates that appointment of persons to be district judges in the state and their posting and promotion shall be made by the governor in consultation with the High Court exercising jurisdiction in the state. According to Article 234, appointments of persons other than district judges to the judicial service of a state are to be made by the governor in accordance with the rules made in that behalf after consulting the State Public Service Commission and the High Court exercising jurisdiction in relation to the state. Control over the subordinate courts under Article 235 is vested in the High Court. Article 235 provides that the control over district courts and courts subordinate thereto, including the posting and promotion of and the grant of leave to persons belonging to the judicial service of a state and holding any post inferior to the post of district judge, shall be vested in the High Court, but nothing in this article shall be construed as taking away from any such person any right of appeal which he may under the law regulating the conditions of his service, or as authorizing the High Court to deal with him otherwise than in accordance with the conditions of his service prescribed under such law. Stop.